acting on some tips, raided the place, and they had set up a controlled buy of a cocktail pouch. And when the transaction was made, they raided it, they seized various bottles, and he was charged with selling liquor without a permit. And the statute billed it as a misdemeanor, punishable by, I think at the time, up to 30 days jail. He denied it. Our defense was that he had to do with it, no knowledge. It was just a waitress selling it on the side. He refused to plead or take any offer. So the case went on the trial list. And as I was preparing for trial, I checked all the updated statutes. This particular statute was one of those, I call them a roadmap statute. It would have the offense shall be punished in accordance with the penalties established in some other section. And then you go to that other section, and it's sending to a third section. And the third section, again, at one point had said, like 30 days in jail, making it a misdemeanor. Well, that section had actually been updated or amended by the state legislature to, just made it an administrative sanction. It shall be subject to, an action by the Commissioner of Consumer Protection, something along those lines. So it basically made it into an administrative proceeding where if you sold liquor without a permit, you no longer faced a criminal penalty. It was at most fine, and even then, an administrative fine. So at that point, it was no longer a crime. Don't know what the legislature was thinking when they changed that. It might just be one of those, they amended one section, and because this statute had a cross-reference to another penalty provision, it wound up modifying that statute too. But anyway, my client was no longer charged with a crime, but the penalty was an administrative sanction.